When the screen goes dark and the world won't start, you know who to call, yeah. Watching you struggle with that frozen screen. 3 days now and you're losing your mind. I see you tapping but nothing's working right. Daniel's got that look in his eyes. From sunrise to the end of the day, you're always fixing what's broken away. Why do you always stay when everyone else would walk away? Why do you always care, Daniel? Why you always there? Coffee's getting cold while you run diagnostics, explaining every step like I'd understand. Your hands move fast across the keyboard, magic, making sense of what I can't comprehend. From sunrise to the end of the day, you're always fixing what's broken away. Why do you always stay when everyone else would walk away? Why do you always care, Daniel? Why you always there? Maybe it's not about the broken parts. Maybe it's about the way you see. Every problem has a beating heart. You won't give up on me. Now the screen's alive and everything's running smooth. You pack your tools with that quiet smile. I know tomorrow when something breaks loose, you'll be back here in a little while. That's why you always stay when everyone else walk away. That's why you always care, Daniel. That's why you're always there. The screen goes dark and the world won't start. I know who to call, yeah.
Well, welcome to the show. Today is Wednesday, which is Judge Boyd's Day today. I want to wish everybody a very happy Thanksgiving. I am not going to be here tomorrow. I am taking that day off, so there'll be no live stream tomorrow. So everybody just have a wonderful Thanksgiving. Eat, stuff your faces, and watch football. All right, everybody, let's get started with Judge Boyd. So share screen. Go back to StreamYard. Do this.
The defense will have 20 minutes to speak with you.
Thank you, Your Honor. May I begin?
Yes.
If I could just have a 5-minute heads up.
Yes.
Well, good afternoon, ladies and gentlemen. How are y'all doing today? Thank you. As you heard earlier, my name is Adam LaHood. I'm a defense attorney. It's my privilege and pleasure to be here today representing Ms. Shelby Rodriguez. Amy Owens, my co-counsel, has helped me out throughout this whole process. So we're here for Verdire, State of Texas versus Shelby Rodriguez. And what does Verdire mean? Anyone know? It means to say or speak the truth, okay? Coincidentally enough, there's another term in legal called verdict, which also means to speak the truth. Veritas dictatum, right? And that's what we're here for, is the truth. Especially during this process, I'll tell you something. There's no right or wrong answers, only honest answers. Even if you think it's silly or dumb, I want to hear from you. But most importantly, I want you just to be truthful. I promise you have my appreciation, the court's appreciation, everyone's, okay? Start a question for you. What is the most important document that you've ever signed in your life? Let me ask you, do I have any veterans in here? Well, first and foremost, thank you for your service. At some point, I'm assuming you had to sign a contract. Is that correct? Okay, pretty important. Something you signed away you possibly could even kill. At the end of this term, we're going to ask the 12 lucky you that are selected for this process to sign something that's equally, if not more important. And that is this. It's a sample verdict form. I typed this up. They all kind of look a little bit differently. But on this form, it says, we, the jury, find Shelby Rodriguez either guilty or not guilty. We're on the criminal side of the courthouse. On the red brick building that we have over there, they're dealing with civil cases, family law matters, monetary disputes, things of that nature. All very important. I'm not going to take away from that. But on this side exclusively, we're dealing with somebody's life and liberty, okay? And that's a tremendous responsibility, and that's why it's absolutely important that you talk to us and let us know what you're thinking. Fly through some of this. This is just what the law says aggravated assault with a deadly weapon is. Many things can be a deadly weapon: a firearm, knife, bat, stone, glass, rock. We're not going to get into the specifics of the case with you, but just understand that it's either somebody assaulting or threatening to assault. That what rises to the level of ag assault with a deadly weapon. Again, I think we told you no wrong answers, only honest answers. Judge Boyd hit on this. There's a massive range of punishment in this. You can assess anywhere from probation on a case all the way up to 20 years in prison. And that is a very, very wide range, okay? Kind of unique to Texas law. A lot of states have much narrower ranges. However, that's just the way we do it. Just a question, and you don't know specific facts, but just knowing that it's an aggravated assault, is there anyone here who could never consider probation for this offense? You're saying you're here. If they were convicted, it doesn't matter if it was threatening with a gun, a knife, a glass bottle, whatever. You could never consider probation under any circumstances. Number 49? Thank you, sir. Number 19?
Not necessarily. I'm just a little fuzzy on what we mean by aggravated.
So aggravated assault is an assault is either threatening to cause bodily injury or harm or actually causing bodily injury or harm. What makes it aggravated is the addition of an allegation of a deadly weapon. Deadly weapon can be a firearm, it can be a knife, it can be a club, glass bottle. In most cases, you're talking about a knife or a firearm, okay? That's what makes it aggravated assault. And as a result, it raises it from what would be a misdemeanor up to a felony. But good question. So number 49. Anyone else? All right. Gonna kind of pass that one. Talk about burden of proof in a case. We tell you the burden of proof is always on the state to prove each and every element of the offense. All right. You saw the prosecution here show you something, says on or about a certain date in Bexar County, Texas, a defendant, namely Shelby Rodriguez, did there commit the offense of aggravated assault against the peace and dignity of the state, etc. So they have to prove each and every element. So let me ask you, let's say that you heard the evidence, you heard everything, but it turns out that you think it actually happened in Guadalupe County. What would your verdict have to be?
Not guilty.
Not guilty. Who said that? Number 27. Why is that?
Because it's not in the county in which she's been accused.
Absolutely. Did everyone hear that and understand that? Okay. You may think it's a technicality, but it's very, very important. Okay. We have these safeguards in place to protect the accused, to protect society at large, and it is always the state's burden to prove each and every element beyond a reasonable doubt. So if you had, for some reason, a doubt as to which county it happened in, you would have to acquit. Does everyone understand? Okay. And we talked about what is beyond a reasonable doubt. Judge Boyd made reference to it. They used to have a definition for us before I started practicing law. The state got rid of it, and then the federal system followed shortly thereafter. We can't tell you what that number is. Number one thing is people say, well, they have to be 70%, they have to be 65%, they have to be 90% sure. I don't know, and I can't tell you. What I can tell you is there's different degrees and different levels. I know it's kind of a small screen, but down here we have reasonable suspicion. That's enough for a cop to pull you over just to see kind of what's going on, right? Maybe you see some swerving, thinks there might be some drinking and driving going on, just enough to kind of stop and investigate. Lowest level of the spectrum. Beyond that, we have probable cause, which is less than 50%, and that is enough to arrest somebody. Doesn't mean they're going to get convicted, but they could be arrested, taken downtown, magistrated, put through the whole process. And a cop doesn't have to even be 50% sure on that. Beyond that, we have what's called preponderance of the evidence. My apologies, the screen shrunk it down for some reason. Preponderance of the evidence is 50% plus just a tiny bit more. So if you think about a scale that's perfectly balanced, even a slight feather, a peppercorn on one side or the other is going to tip it and one side's favor the other. That's enough to prevail on preponderance of the evidence. That's what you have in a civil case. If you have like a car wreck case, rear-ending, slip and fall, things of that nature. Beyond that, we have what's called clear and convincing. These are CPS cases. If a case of child neglect or abuse is proved by clear and convincing evidence, the state can actually remove a child from their parents' home, possibly even remove them from their custody, potentially forever. Okay? That's clear and convincing evidence. That's still not as high as beyond a reasonable doubt. And we can't tell you where this number goes, but beyond a reasonable doubt is how high and how certain you must be of every element before you convict somebody of a criminal offense. Okay? It goes back to what we were talking about, why we have such a high burden. You're dealing with people's liberty. You're dealing with people's lives, and the state always has the burden to prove each and every element beyond a reasonable doubt. If you have a doubt as to anything in there that you think they fell short of it, even if they hit 9 out of 10, 99 out of 100, and there was 100 elements for that one you just weren't sure on, you still must acquit. Does everyone understand that?
Yes.
In the penal code, we have different, we have offenses. There's also justifications, and what we have is self-defense. This is straight from the code, chapter 9.31. You don't need to memorize this. Anyone selected for the jury, you don't have to memorize any law. The court will give you the charge. They'll give you all the law. All you have to do is listen to evidence and make a decision what you believe. Basically, it says a person is justified in using force against another when to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. So what does that mean? It means if you're walking down the street, somebody comes up, pushes you, and takes a swing at you. Does everyone understand that you have a right to fight back?
Yes.
All right. That's what self-defense is talking about. There's different levels of self-defense, and this is something we largely leave up to the jury if it comes up at all. Self-defense could include all the way up to the use of deadly force. It could even include a defending person killing their attacker if it was called on. Okay. So again, just as you saw in the punishment range, there's a wide range as to what can be justified for self-defense. Again, deadly force is justified if the actor reasonably believes the deadly force is immediately necessary to protect the actor against the other's use or attempted use of unlawful deadly force. Okay. So again, somebody threatens you with a gun, a knife, a club, whatever. You are allowed to display deadly force, or in some cases, even shoot up to killing the person if it was necessary to defend your life and person. Okay. Is there anyone who thinks that a person is never justified in using should be deadly force against another person, no matter the circumstances? And let me explain a little bit about what deadly force is. It doesn't necessarily mean you have to stab, shoot, club someone. It could be the display of a firearm, display of a knife, saying back off, get away from me. I don't want to hurt you. That actually rises to the level of deadly force, but it could be justified as we just saw. So I said lethal. That was a typo on my part. Should be deadly force. So you would think that, it's an unfortunate deal, but if you're being threatened, you don't have a right to use deadly force in self-defense. If you feel that way, it's fine. Just let us know. Anyone? All right. Does anyone have any religious, moral, or ethical obligations to considering threatening another human's life to be justified? So maybe you have deeply held religious beliefs. I think we hit on this already. But does anyone think, due to personal religious conviction, that somebody is never justified in using deadly force, no matter what the circumstances? Anyone? That's not one. Here's a question for you. Say it asks you, and I know a lot of cards went up, of how many people were either victims or new victims of domestic violence, correct? All right. It's something that I think to great benefit has gotten a lot more publication in the press. It's come to light. It's no longer the dirty secret that happens behind closed doors, because nobody deserves to be abused. Nobody deserves to be victim. All right. I think we can all agree on that, correct? How many people think that victims of domestic violence and abuse always speak out immediately against their attacker? So you get hit, something happens, no matter what, they're going to run immediately and go to the police, tell someone. How many think the opposite? That a lot of times they internalize it and they don't see it? Okay, I don't need to call the numbers. Ma'am, right here in the front row, what's your name? Kate, will you stand up, please? Sorry to pick on you, but I just needed somebody. I think you raised your card for this one. Why do you think domestic violence victims don't always speak out?
I think it's kind of a muddled issue. There's a lot of shame. There's love for the person that may be doing the abusing. It's really complicated and everybody has their own reasons.
Okay, thank you very much. Does everyone agree with Kate? All right, okay. So we have domestic violence, we have domestic abuse. Again, it's kind of a nasty, dirty secret, but unfortunately, no, it's prevalent throughout the country and indeed throughout the world. Any opinions? Do you think it's more common that a domestic violence victim will lie and cover for their abusive partner? Kind of what Kate was just talking about. So, how'd you get the black eye? Well, I fell down, or, something happened. A door swung open and hit me. People think, how many of you think that kind of thing happens? A lot of us, right? And I think we understand why, correct? There could be shame. How many think domestic violence victims are fearful for their life? All right. Maybe they're afraid to leave for reasons, breaking up families, things of that nature. Okay. We talked about this whole process that you have a duty to serve, and all of you are fulfilling that duty by showing up here today. And again, you have my thanks, and I mean that sincerely. Jury duty is not fun. I think y'all get paid, was it $10 a day or something? It's whatever it is. 20. My goodness, they went up. Last time I did it was 6.
Yeah.
But still, if it was 200, it's probably not worth it. It's not a fun procedure, but this is something that simply can't happen without all of you here. Okay, and you have a duty to serve, but equal to that, you also have a duty not to serve in some circumstances. Let me explain what I mean by that. Each of y'all are different. I get about 20 minutes to talk to you, try to get to know you. You try to get to know me. Truth is, we could spend a year together, and I don't know if I'm going to get to know 65 of you well enough, to call your friend, right? I don't know where you come from in your experience, but if you cannot be fair to both sides, so you have a prejudice and goes where, man, I'm going to be pro-defense, and I just don't believe anything the state says, or vice versa. You just don't believe the defense. Please let us know, okay? You have a duty to both sides to serve, and I mean that when I say it. Even if you're going to be pro-defense and you can't talk to the state, we want a fair trial. We need a fair trial. Our whole system depends upon it. Y'all, everyone understand that?
Yes.
Let me see if I have an example in here. I'll just tell you a quick thing. Kind of funny story. When last time I was up for jury duty, it was about 5 years ago. Literally the day before, I got rear-ended and I got hit by an uninsured motorist. It was bad, right? My car was totaled, everything. I mean, I was going to be out money, and I wasn't happy. So it turned out I actually got called for a criminal trial. Now, how many think, let's say I went and it was a car accident case on the civil side. Do you think that maybe my judgment could have been clouded by what happened? Right. I'll tell you, absolutely, it would have been. I try to be fair to everyone, try to be honest, but I'm a human. I think everyone is, and that's what we're trying to say. Just because you may not be the right juror for this case doesn't mean you're a bad person. Doesn't mean you're not doing your duty. Just not every case is right for every person. and that's something you think, that's what we're trying to just have you talk to us about it, and we can fix it.
5 minutes.
Thank you, Your Honor. We're gonna fly through this part. Presumption of innocence. Somebody raise your card. Who knows what that means? Presumption of innocence. 34.
You're presumed innocent.
Absolutely. Thank you. So as it stands right now, Shelby Rodriguez is presumed innocent. That means we sat 12 of you, the judge said, okay, you need to go back now. You didn't hear any evidence. Go find a verdict. What is the only verdict that you could ever possibly return? Not guilty, right? You haven't heard any evidence. In fact, I'll tell you, it's the only presumption that carries throughout the entire trial proceeding. A defendant is presumed innocent up until the moment the jury says otherwise, namely saying that we find them guilty beyond a reasonable doubt. As I said, it's the only presumption. We went through a lot of this stuff. Types of witnesses you expect to hear from in a case. Might hear from the complainant, alleged victim. Agreed. Possibly eyewitnesses, police officers. How many think that a police officer's report would be helpful to see and read? All right. You're not going to see a police report. Does anyone know why? It's hearsay. Okay. Everything we do, every step we take is governed by the rules of evidence. Okay. In that case, it's an out-of-court statement. It's not going to come into evidence. And I like that example because sometimes jurors get mad thinking that we're hiding something from you. That's not the case. There's just rules. There's a lot of stuff that we get to see and everything's behind the scenes that doesn't make it to a trial just because that's what the rules say. What are some things that we look for when we evaluate a person's credibility? Anyone, just raise your card. Oh, come on, don't make me call someone. No one? 34.
I'm good at this, I'm good. Evaluate.
Oh, I'm sorry. I'm gonna need you to speak up so the court reporter can hear.
History of the alleged crime.
Like background history?
Yeah.
Okay. Maybe body language, right? Consistency in the story, history, dishonesty, or common sense. We have the Fifth Amendment. Again, I know we're running short on time. Basically, it means that a person cannot be called to bear witness against himself. So during the state's case, they can never call Shelby. They can never call any defendant to testify. If a defendant chooses to testify, she could do so on her own, but the state cannot compel her. Does everyone get that? All right. And we talk about why people don't testify. Nervousness. Real quick, when they did a psychological study of the greatest fears of Americans back in the late 90s, fear of dying was number 2. Does anyone know what number 1 was? Public speaking, yeah. It's a miserable experience for a lot of people to stand up and talk, right? We chose somehow to do this for a living, but it can be nerve-wracking for somebody to talk. Could be lack of memory, they're blindsided by allegations, fear of public speaking. Just simply some people don't talk well. You understand? Get past that. Kind of a catch-all question here. Is there anyone who feels they cannot be a fair and impartial juror for any reason that we haven't covered? I think we've covered a lot of it, religious objections, but there's something that would make you unfair and biased. This is your chance to let us know. Is there anyone, for any reason we haven't covered, just raise your card and let us know. 32.
Transparency, I want that one for this process right now. So.
Okay. And do you think it would prohibit you from serving as a fair and impartial juror?
I think so because it's my stepson, and so the circumstance behind anyone else.
I got you. So I got to nail you down to an answer. The way I always say this, it's like you're getting married, right? You're sitting there across your husband. They ask him, do you take her to be a lawfully wife? And he says, me. It just doesn't work, right? So I need a yes or no. Do you, and I'm sorry to put you on the spot like that, but it's just what we need. Okay, and I appreciate your honesty. Anyone else? 30. Yes, sir.
Yeah, similar situation.
Just going through some.
Yeah.
I mean, talk over you. My apologies.
Yeah.
That's number 30. Thank you, sir. Anybody else? All right. And the last one is kind of a catch-all. I know we're almost out of time. Anything else that we can't get there, and perhaps there's something going on with you. You're in physical pain. You have a bad spine or bad back. You can't sit through something. Is there anyone that has any kind of ailment like that that would prohibit you from sitting on this jury? Number 62.
My favorite, so if you want, it's hard for me to get up.
Okay.
So
I understand. Thank you, ma'am. Anybody else? I think we're out of time.
Yes.
Ladies and gentlemen, thank you all very much.
All right, ladies and gentlemen, I'm going to have you all step outside, leave the numbers behind, and then we will call you back in and let you know who's been selected for this jury. So do not leave. Just step outside for a moment.
Would you like to sit on the side?
All right, so everybody, you all agreed that
That's your seat. That's your
Sorry,
seat.
Judge.
you all will take up your opening statements today in defense, if you have any opening statements, and then there'll be one witness called today. And then we will have Thursday afternoon, we'll start at 1:30, and then Friday is all day.
Yes, Your Honor.
With that schedule, I think we
And-
can pretty much do closing on Friday.
I believe so.
Yeah.
Right, and then you all will have a jury charge before you leave here today, because we're nothing if not efficient here. Right? And so-
Is it the subarctic temps keep you all on your toes?
I've already anticipated that based upon the voir dire.
I mean, look, I'm not trying to tip my hand.
Yeah.
But
You only have so many
You only
options.
kind of really,
So I've already
You have lots of
anticipate the
options.
self-defense, so,
Judge,
and then we will, and I'm assuming, is there gonna be of third persons or just self?
no, I don't think third person's gonna come in. No,
All right, so we'll make sure it's there.
No, it's not.
Okay.
do I have a time for a quick question break, Your Honor?
You have 5 minutes.
I'll be back in less than 5.
Ashley, you want candy?
All right, should I put you on time?
Does she want any candy?
No, I'm trying to do the diet thing.
I'll go for it.
Yeah.
Huh?
Is it fat-free?
Oh, yeah.
No sugar?
Uh-huh.
No, okay, you sound like Deputy Lord.
No.
No. Well, okay, let me just tell you what I've been doing for the weight thing. I have been doing the calorie counting, which some people say that's a good thing, that's a bad thing. So I ended up going to have lunch with a friend over the weekend at the Cheesecake Factory, right? And so they say, if you're going to calorie count, you've got to be honest with yourself. So we're there and they say, Stephanie, let's look at the cheesecake.
Oh.
So I look at a slice of cheesecake. I said, well, here's the question I have to answer for myself. I said, if I eat this cheesecake, yeah, I said, if I eat this cheesecake, that means I can't eat anything else for the rest of the day. And I have to borrow calories from tomorrow. Like I'm in debt. So they're like, Stephanie, are you going to actually not eat it? I'm like, no. I'm like, that's a price that I am not willing to pay.
I actually
So-
lost weight when I came back from my cruise. I
Mhm.
was like 6 pounds lighter. It was all the walking.
Oh, yes.
I mean, I walked like 25 miles in one day. It was just.
That's why I love being in Europe. You can walk everywhere. That's how you can eat everything. You can walk, you're walking everywhere.
That's what we did in Montana. Like all they do is hike everywhere. And I was like, at 8,000 elevation. I was dying.
Okay, but then now that you've done that, Amy, you're ready for the Olympics. What spot can the US put you in?
Yeah, no.
Huh.
Well, the highest mountain I ever climbed was 14,000 feet and outward bound when I went over
Wow.
the summer for 19 days with the backpack on my back, just hiking Telluride.
We were in Paris and we were on the outskirts of Paris where they filmed Valkyrie or whatever. So we were going to see the castle. I was in the vehicle in the back seat, 2 women from Spain and another friend, right? The women from Spain, when the driver went to pick them up, they're outside just smoking, right? It's an older lady. And at that time, with my age, she is probably maybe 20 years older than me. So she's in her late 60s, early 70s. We go to the castle, but the time we get out of the vehicle, she's lighting up again and our companion is lighting up again. And we get to the castle and I'm saying to myself, these people are not going to make it up these stairs. So next thing I know,
Okay.
I'm climbing up the stairs and they are steep because people were teeny tiny, right? And nobody had any type of,
Okay.
designs where it says this is the length of the landing and all of this. So, right. So I'm climbing up. The lady from Spain is climbing the stairs and smoking a cigarette at the same time. She and her companion have long since passed me. And and I was in shape at that time. I'm starting to huff and puff. And I say, excuse me, how long till we get to the top? Because we're trying to get to the, what are they called? Turrets or something?
Yeah.
So we're trying to get there and walk outside. And so the director's like, oh, Stephanie, We're almost there. And my friend's like, Stephanie, she's not telling the truth. I just turned the corner. We have so many more corners to turn. And by the time I make it outside, the lady is already up there just smoking a cigarette. I should have ran up these stairs and just dealt with the fallout from it.
So funny.
Cracks me up, George, George is safer's a heavy smoker.
Me too.
Mhm.
So he smoked all throughout the academy and he played soccer. In fact, he actually had a contract to go
Mhm.
pro. So he would smoke a cigarette during the game. And, when they had a break, he'd puff about 3 down rapid
Mhm.
successions, go out there and play. I mean,
I was driving one
it's,
and I thought maybe I wasn't driving, I was dreaming because I saw a lady jogging and smoking at the same time.
No way.
Yes. You can ask Jamisa because I picked up the phone and called her and I said, Jamisa, I'm making sure that I'm not dreaming. I said, but remind me of this conversation. And she's like, no, you're not dreaming. I'm like, there's a lady jogging and smoking at the same time. All right, these, we're going to go on the record. All right, I'm going to let you all know which jurors will be on the jury. I'll call them out by number. On page 1, number 8, 9, 13, 14, 15, 16, 17. From page 2,
I'm sorry, hold on.
what you need me to say again?
If you don't mind, please, you went a little fast.
All right, so from page 1, it will
Uh-huh.
be number 8,
Uh-huh.
9,
Okay.
13,
Mhm.
14,
Mhm.
15,
Mhm.
16, and 17.
So,
Any objection to those being on the panel? State.
once, 9.
no objections, Judge.
No
No
objection from the
objection
state.
from the defense. Any objection from the state?
No objection from the state.
From page 2, the following jurors: number 24, 25, 31, 35, and 36. Any objection, state?
24.
Judge, I'm sorry, will you read those numbers again? I apologize.
24,
Uh-huh.
25,
Yes,
Mhm.
31,
yes,
35, and 36.
No objection from the state.
Any objections from the defense?
no objections, Judge.
And the alternates will be 43 and 44. Any objection, state?
43 and 44. No objection from the state.
Defense, any objection?
No, Your Honor.
All right. And we can go off the record. Let's bring the jurors in, please.
Are you wearing 7 layers and
904, State of Texas versus Tanya Ortega. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Umberto Sullivan.
And are you Tanya Ortega?
Yes, Your Honor.
Ms. Ortega, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonition. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of aggravated robbery? It's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand? I'm
Yes.
showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $1,500 fine, affirmative finding of deadly weapon. State recommends deferred. There's to be restitution, if any, to Michelle Michelle Young. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, sir.
State?
It is, Your
When
Honor.
you're outside the agreement, the state is requesting that your community supervision be for a term of 8 years. There'll be a TAP evaluation, 200 hours community service restitution, and no contact with Michelle Young. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State Exhibit number 1 with office attachment.
No objection.
Proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right. So what started this argument? What's the argument about?
So this lady was upset with me because I was assaulted by her boyfriend. He hit me with a gun from behind and called in this aggravated robbery. Said that I held a gun, took her phone and her makeup.
Okay. And I see what the witnesses are saying as well. So what is up with the tattoos, the writing over the eyes? Whose name is that?
I have 2 kids. It's my son and my daughters. I've failed as of yet to be a mom that I really want to be for my kids, and I feel somewhat this is a way I can express to them that I love them. It's silly in part, but maybe if they see something, they know that my mistakes are not towards them, and the love that I have for them is just bad choices that I've made.
All right. And how old are your children?
9 and 12. My parents have adopted them to the state of Texas so they could go to college. Have a good
Well,
stable home.
they adopted them so they could go to college, but you're right, that last part for them to have a stable home.
Yes.
Do you have
I
any
talked
plans to
them-
have any more children?
No,
Okay.
I'm done. But I've taken parenting and I've done a lot of things while in TDC, and I went to college in TDC and I got an associates in horticulture, and I'm in their lives, and I can't just go in and rearrange everything that my parents have
No.
done. I don't have that right. So I'm grateful that my mom and dad allow me to co-parent with them, and slowly but surely I will re-enter their lives and use my mistakes as an example of things I've made a pathway for them not to experience.
All right. And what is the tattoo on your chest about?
It's a cover up. I've like I said, I've made poor choices, and it's a name that I wanted to get covered up.
Any gang affiliation with you?
No, Your Honor.
Drug use?
No, Your Honor.
So why did Child Protective Services come in?
Well, my parents adopted my kids 7 years ago, and at that time I was on a bad route.
All right. So what drugs were you using at that time?
I was smoking marijuana.
CPS does not. I did a lot of CPS cases. There was more going on than smoking marijuana. What else was going on?
No, I was just smoking marijuana, but I was in a very bad relationship with my daughter's dad, and
Mhm.
that was another factor to bring into the
And what's
Okay.
that father's name?
Eduardo Sotelo, but he's dead. May he rest in peace.
All right.
He died of a OD on synthetic marijuana. His heart exploded 3 years ago.
Okay. All right. This is what the court is going to do. $1,500 fine. It will be probated. There's an affirmative finding of deadly weapon. There's to be no contact and restitution to Michelle Young. There's to be no unsupervised contact with minors. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Random regular UAs. We can do a gang evaluation. Field visits, 1 time per month until further notice. 200 hours of community service restitution. 8 years deferred adjudication, anger management, and I'm going to want 90 sober meetings in 90 days. Anything else, probation? All right, is there anything else you need from the court to be successful?
We're just gonna ask if she chooses to continue her academic career, could some of those hours be used for community service?
Yes, but I will tell you this, if you're continuing with your academic career in this court, you must be doing at least 8 hours
Okay.
per semester.
Your Honor, is there any local parenting classes that you
Sure.
could refer me to?
Yes,
There's always.
all right, I'll add parenting classes.
Thank you.
And if she completes when she completes the parenting classes, we can knock off 100 hours of community service restitution.
Thank you, Your Honor.
You're welcome. Is there anything else you need from the court?
Thank you very much.
We really appreciate it. Thank you.
Thank you.
All right, good luck to you. We can go off the record. In this court, probation is not easy. That's what the deputies tell me all the time.
But it's doable.
It's-
Very doable.
It's doable. So if there's an issue, discuss it with your probation officer. If you feel like they're not addressing it, you can always come to court and we will address it here.
Thank you so much, Your Honor.
All right,
Thank
you're
you for this
welcome.
chance.
All right, you're welcome.
If you have ED, you might need to work on your mental game. When you're aroused, your brain releases dopamine. That dopamine kicks off a chain reaction, sending signals through your nervous system, helping you get an erection. Most generic ED meds just focus on the blood flow. Near the end of that
CR 011411 and 2023 CR 8904, State versus Tanya Ortega. Can I have parties announced?
Lauren Espinoza for the state.
And Jonathan Alvarado for the defense.
And are you Miss Tanya Ortega?
Yes, Your Honor.
All right, we're going to start with the motion to revoke. To review motion to enter adjudication of guilt and revoke community supervision and First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney. Did you understand it?
Yes, Your Honor.
Are you the same Tanya Ortega who was placed on deferred adjudication in 2023 CR 8904 for the offense of aggravated robbery on December 11, 2023 for a period of 8 years? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 1, on or about the 8th day of August 2025 in Bexar County, Texas, the defendant Tanya S. Ortega committed the offense of theft of materials, aluminum, bronze, copper, brass, less than 20,000 in violation of condition number 1.
How do you plead to that? True or not true?
True, Your Honor.
And state, do you waive other violations?
Yes, Your Honor, state waives the remaining violations.
Any objections to the
No
waiver?
objections, Judge.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to life in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to revoke revoke community supervision, enter an adjudication of guilt, sentence 5 years to do, and then run concurrent with the new staff offense.
Are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
And defense, is this the agreement you're asking the court to follow?
Yes, Judge, we are.
Has she done anything on probation?
She has, Your Honor. She was employed working as a welder for, I believe it was not Toyota plant per se, but maybe one of their subsidiaries, Judge. I believe she had many submissions as far as drug tests. However, she did have a few missed, but she was not testing positive. She had recently gotten out of prison, and she also has some pending case in Uvalde County, Judge. She was on GPS monitor for a long time out of her probation for this court. She was making payments towards that. She was also on pretrial at Uvalde County, having to make payments towards that. She got into a position, I think, Judge, where she was financially unstable, leading to the theft charge that's before you now. Ms. Ortega has not tested positive, and I don't believe the theft was drug related, Judge, as far as like trying to make money to pay for drugs. I think it was something where she was trying to have money to pay for rent and so on, and she makes those kind of admissions in the stipulations on the theft case. So this was something, Judge, where we actually considered potentially going open to Your Honor to continue to see if you consider continuing her on probation, but given everything that was going on in her cases, being also on a parole hold, this was something we came to an agreement with the state for. We are asking you to follow it.
All right. So the underlying facts of the case that she's on deferred adjudication for are not great.
Yes, Judge.
So this is what the court is going to do. The court is finding violation of condition number 1 true. The court is going to find you guilty, revoke. The court is going to sentence you to 8 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. There's to be no contact with Michelle Young, no residing with minors.
When Your Honor can, I have one more request regarding this case. So she does have parole hold out of Bell County. Expecting the court's sentence, we would ask that if the court would consider running that case concurrent with this case, and I do have the cause number on that.
All right, concurrent with?
Bell County case number FR 81006.
006?
Yes, Your Honor.
All right, and what the court will say is with regards to that cause number, only receive credit if there was a warrant issued in this case and if she was in custody for the Bell County matter.
Okay, Judge.
All right, next we're moving on to the 2025 CR 011411. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, you're charged with the offense of theft of material of copper from Home Depot as a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed under 1244 to 41 days in the Bexar County Jail. There's a $1,000 fine. This will run concurrent with 2023 CR 8904. Did you understand that to be your plea?
Yes, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor. States Exhibit 1 and all attachments.
No
Are
objection.
you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
As we ask to follow the plea bargain, Judge.
All right, this is what the court will do. The court will find you guilty, sentence you to 41 days in the Bexar County Jail under 1244, give you credit for any time served. There's a $1,000 fine. Time and money will run concurrently. This will run concurrent with 2023 CR 8904 with a cause number in Bale County FR 81006. There's to be no contact with Home Depot and no contact with Lydia Angel Hernandez. All right, we're going to go off the record. Good luck to you. You're going to have to
Thank
make
you.
better life decisions. All right.
Yes, ma'am.
All right. Good
Thank
luck.
you.
This is the bariatric.
And I already have one. Read the report. I think it was between. Well, so then by the way,
Okay, so.
I want to be. Oh, well, it works that way. It works.
Jason? Jason. So Tony, never heard of, never seen the Wiz, but he has redeemed himself because he knows the songs to Grease 2.
Oh, Grease 2.
Oh my God.
But the first Grease was so much better.
No.
You know how many times I saw Grease 1
How many?
at the movie theater?
How many?
Like 12 times.
See,
And I was like, it came out in 77 or 78.
Yeah.
I was 4 or 5. You know why? My sisters. We would walk the movie theater and the same thing with Annie. I saw Annie probably like 8 times at the movie theater.
Oh, yeah.
And I saw the Christmas Story first row at the movie theater when it was.
But Sean, here's a strike against Jason. You know what he thinks? He thinks Grease 1 is better than Grease 2.
Oh, you think Grease 2 is better?
Oh, we need to have a song off.
John Travolta.
Michelle Pfeiffer's in Grease 2.
Olivia Newton-John. I mean, come on. I mean, don't disrespect her name that way.
Tony,
I mean, to this day, I'm still.
what is better? I know that Jason is first chair, but what is better, Grease 1 or Grease 2? Oh, he just did that because of you. That's all.
Well, that's by Cornelius Cox. You had Cornelius Cox last week saying LSU was going to win.
Hello? Okay, I will. Tell Mom to come get him. Yeah. But Sean, he's like Jackson. Tell Mom, come get him. All right, Norma, Yvette Martinez.
Morning, Your Honor. Good afternoon. Let me get that right.
Good afternoon. Yes.
Scott Sullivan from Miss Martinez.
Oh, and Jason, if you could review that, that's on it. It's not related to this case.
Okay.
All right, yes. So where are we?
We're present and ready now.
Okay,
I talked with the prosecution about some things.
all right. So what are we doing?
We have a plea approved. The government's giving the state's giving agreement,
Judge.
Okay,
Yeah, I spoke with Sean and the defense counsel.
all right, we're gonna go on the record then. Can I have a file stamp for probation, please? Thank you.
Should these glasses be illegal?
All right, court is calling 2023 CR 1876, State versus Yvette Martinez. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
James Scott Sullivan from Miss Martinez.
And are you Miss Martinez? All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, I do.
Are you the same Yvette Estrella Martinez placed on community supervision in 2023 CR 1876 for the offense of intoxication assault with a vehicle serious bodily injury on August 10th, 2023 for a term of 10 years? Is that you?
Yes.
All right, state.
Yes, Your Honor. Violated condition number 42, on or about the third day of October 2024, Bear County, Texas, the defendant Yvette Estrella, is that Estrella? Martinez did then and there fail to obtain and comply with all rules, regulations, instructions, and financial agreements associated with the transdermal alcohol monitoring program in violation of condition number 42.
How do you plead to that? True or not true?
True.
All right, did you understand by pleading true to violation of condition 42, the court could find it true, grant the motion, sentence you to 10 years in prison and up to $2,500 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 42?
Yes.
Court will find condition of 42 true. Is there a proposed agreement?
There is, Your Honor. It is to deny the motion to revoke individual's probation, order weekly reporting for 60 days. Also order her to bring in, or by the end of today, bring in proof that she is enlisted or is enlisted with the DWI intervention program, or because I believe that she had already had it, but then was disqualified because she missed a day.
Mhm.
And then also order zero tolerance to all conditions. And then also order state ISF, but hold that in abeyance.
All right, so here's the court's question. The proof of the DWI, you say intervention program,
Yes, Your Honor.
are you enrolled?
Yes, I was enrolled and then I missed a day, so they kicked me out, but I'm gonna be enrolling in Cicada. If you would permit me to enroll in Cicada, the intervention program.
All right, is she gonna be able to enroll in that today?
Yes,
Money
Your Honor.
wise, she can make it.
All right, so you
If
need,
the office is open,
Well, Judge, that's the only, my caveat that I told defense counsel. I don't know if they'll be able to get over there by the day.
all
We
right,
have to allow till tomorrow.
you need to be enrolled in that program no later than October 30th,
Yes, Your Honor.
by 1 p.m.
Yes, Your Honor.
And the court is going to order weekly reporting for 90 days. Now, the other question is, what's with the alcohol monitoring?
the
Is she
muffled guard.
monitored? Does she have a monitor?
Yes, she does. I'm sorry. She has the scrim on her ankle. I apologize.
Okay, no problem.
I thought I had to go monitor her personally there. for a minute. Thanks,
Okay.
Judge.
Continue with Scram until further notice. And I don't normally order zero tolerance, but I'm putting it here just so you will know. It's zero tolerance. Do you know what that means?
I cannot have any violations. I cannot mess up.
All right. All right, is there anything else from either side?
Judge, the only thing we had asked is to hold the state ISF in advance.
All right. And ISF, and that'll be held in advance.
Nothing else from the state.
Anything else, Council?
Nothing, Your Honor.
All right, we can go off the record.
I just want to say, because I feel like it's right, that I am truly sorry about what happened to the gentleman that was injured. You know, it breaks my heart knowing that I could possibly go to prison for this stupid choice that I made. And I love my kids so much and
All right, so here's the thing. Let me just tell you. People who are on probation, everybody loves everybody. Everybody intends to do better. But then what ends up happening, they pick up a motion to revoke. So what I'm stressing to you, because you've been here before the court, and there have been issues with monitors, there's been issues with you not following through on what you're supposed to follow through on. You're looking at 10 years in the prison. And Ms. Abrams, also do a referral to felony drug court.
Did not meet the criteria.
But when was it done?
I received the outcome.
If you have dementia, you should never drink
On 10/2.
All right. All right, so here's the thing. How old are your children?
8 years old and 3, 4.
Do they live with you? All right, so let me just tell you, if you end up going to prison for 10 years, you do the math. Your 8-year-old, if you serve the full 10, they're going to be an adult by the time you come out. The other child, not going to know you. Somebody else is going to be raising them. So you had better get it together. Otherwise, somebody else could potentially end up raising your children. Do you have somebody lined up to raise your children if you don't do right? Then you know what could end up happening? They could end up in foster care. You understand?
Yes.
So you're going to have to do better. And I will tell you, in this court, people have drug problems, people have alcohol problems. I always say, you know, let your probation officer know what's going on. That's the thing. But you got to do your part. And when I tell people to let probation officers know if they have an issue, it's not going to probation and begging them, oh, I really don't want to do this condition. Or, guess what? I got kicked out of the DWI intervention program. That's not what I mean by going to your probation officer help. I mean, picking up the phone. I'm about to use alcohol. Where can you send me? What can I do? That's what I mean by help. Help with you being successful in your probation and not drinking anymore. Because otherwise, what's going to end up happening, you're looking at 10 years in prison, and that's potentially a full 10 years without you being in your child's life. And I will tell you, CPS court, your 8-year-old, it's hard to get 8-year-olds adopted and 10-year-olds. People always want a little baby. Your younger child, though, somebody will adopt your younger child. And then your children will be separated. And when you come out, you're going to be trying to find them. You understand?
Yes.
So I'm not being mean, but you had better start stepping up. You understand?
Yes, Your Honor.
All right. Good luck to you.
Thank you.
Thanks, Your Honor. Good work. May we be excused?
You may be excused after she speaks. Well, you can. She needs to speak to probation.
If probation wants me to speak with them, I will. Doesn't that, can I be excused?
Oh, sure. You're excused.
I'm
But
gonna stay here in the courtroom.
all right. I appreciate that.
Thank you, Your Honor.
You're welcome. So Yaya, did they ever find the driver of that vehicle?
They haven't posted any updates, they're just still showing the white people.
All right, Yaya, here is this one. Oops. Paperclip is fine. All right, Norma, Pedro Flores, what's happening? All right, so recall it for the 31st. Is Pedro Flores in custody? Pedro Flores? Hi. Hello. Hi, your attorney is actually in federal court.
Okay.
And federal court takes precedent over state court. So we're gonna bring you back on Thursday and your attorney will be here at that time, okay?
Okay.
All right, thank you for your patience.
Howdy, y'all. If you live in an Alabama zip code.
All right, and then Anthony Harris.
Yes.
All right, Anthony Harris, if you'll come down, please. All right, Mr. Harris, we're gonna call you back on Thursday. Your attorney is in federal court and federal court takes precedent over state court, okay? So we'll bring you back on Thursday.
Yes.
All right, thank you. Thank you for your patience.
Andrade.
I've seen it happen.
Jason Andrade,
Yes, Judge.
where is he?
He is not present, Judge. I spoke with him 12 minutes ago.
Mhm.
He promised he would be here tomorrow morning.
Oh, he needs to be here today.
I understand that. Judge.
Okay, all right. Deputy, could you make an announcement for Jason Andrade in the hallway, please? So how's it been going?
Reasonably well.
Okay. Norma, is he on a PR bond? I don't see where.
He's on bond, but I'm not sure what kind, Judge.
Okay,
Oh, I take that back. He's a commercial bond.
all right, thank
That's where I
you.
got the phone numbers that
All
I
right,
didn't respond to until today when I left a message and said something about a warrant.
all right. Court is calling 2024 CR 009620, State of Texas versus Jason Andrade. Could I have parties announced for the record for the state
Jason Garahan, Your Honor.
defense?
Bud Rittenhour for the defense, Your Honor.
All right, this hearing was scheduled at 9 a.m. The court called the docket at 9 a.m. There was no response for the defendant. The court went on recess and now we're back at 1:30. It is now 1:58 p.m. and the defendant has still not answered. Deputy, did you make an announcement for Jason Anthony Andrade?
Just cut off.
All right, defense, have you had contact with your client?
I have, Your Honor, this afternoon. We spoke by phone. He will be here tomorrow, what he promised.
All right, state.
States that we're requesting a bond forfeiture, Your Honor.
All right, that will be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you. You may
May I
be
be excused?
excused.
Thank you.
Yes. Thank you, sir. I'm ready. James Lord.
Yes, Your Honor. In the middle.
Hello, Mr. Lloyd.
How you doing, ma'am?
I keep wanting to say Lord James. I think that flows
Yes,
differently.
yes.
Right? All right, so counsel, where are we on discovery?
I believe we have everything, Your Honor. At the last setting, I did confer with ADA Daniel, and he had taken some notes to contact the CW before making an offer. And I don't believe the officer had responded. ADA Tony looked into that, and we're hoping to come back within 2 weeks or to get an offer to get a plea deadline date.
All right. All right, Norma, if you put this on November 19th. All right, and state at that time you need to be prepared to tender an offer.
Yes, ma'am.
All right, is there anything else?
Nothing further.
All right, do you have any questions?
No, ma'am.
All right, we'll bring you back on November 19th.
Yes,
If
ma'am.
for any reason your attorney wants you back here sooner, all he has to do is let us know. We'll have you brought over sooner.
All right, thank you.
All right, thank you.
Thank you, Judge.
Yes, I'll put it to you. Yes.
When it comes to snow, go with
Yes.
I mean, this is associated with the DWI, and I think that it's an ag assault. I mean, I was trying to look it up, but it crashed on me just now, Ken.
Okay.
But I mean, I think, I don't know if we want to bring him
Oh, you know
in.
what? Let me ask you this. Norma, can you call Joseph Statesman back, please? Because I see who the attorney is, so
Oh, okay.
Joseph may be able to address things.
Okay, Judge.
Otherwise, we'll set it for a hearing.
Yeah, because it's a 6-1, and it's like, I think all previous ones were about the same, and he's like testing where it's like, seems like it's alcohol use.
Okay. All right. Chelsea? Yes, so where are we?
Judge, this is a compliance hearing.
Mhm.
Since the last time we were here on the MTR, Ms. Chelsea has been evaluated for the Alpha Home and she's completed her TAP evaluation. She did not meet the criteria for Alpha Home, and the TAP evaluation came back with the recommendation for supportive outpatient treatment, monthly UAs, and sober support meetings. At this point, we are looking to release Ms. Chelsea with the previously mandate of GPS through work release, partial, and all of her other conditions to include supportive outpatient treatment.
And where is she gonna be staying?
Judge, we would have to talk to Ms. Chelsea about that.
All right, she doesn't have a place to stay. So let me ask you all this. Could you try maybe Victory Outreach? Because I think they have a women's, but she doesn't have a place to stay. And honestly, this is the best that she has looked, and it's been since she's been in custody. So you need a place to stay?
Yes.
Okay.
We do try Victory Outreach. We can also, I can talk to Ms. Chelsea about the House of Discipleship as well. See if that's a possibility.
Let me ask you.
Hey, Monica Aguilera is,
This one. Because it has Monica E on there.
we had approached before on prior violations.
James?
And we were notified that he hired counsel.
Okay.
The charger actually repairs your phone while charging, and everyone thinks it's too good to be true. Nobody believed me at first, but now everybody wants one. My friends roasted me for buying a fast charger online. They said I got scammed, but then I showed them what it could do. Now they're all begging me to send them the link. It's called MagVolt Pro, and it's nothing like the chargers you're used to. Now this thing actually charges your phone from 0% to 100%.
I'm finding something. I was here on September 10th, when the jacket happened. And I said to Monica, I'm in the 187th. Maybe Dirk hired Monica at 8. But she was here, she confirmed. Hey, get up. I don't know if her. And she's from another county. She practiced elsewhere before she came here. We've only been here a little bit of time. She was. Updated. Okay, sorry, thank you, Norma. Okay, good. Bye.
Yes, bye-bye, thank you. All right, so we need Joanne Eckel. Jonathan Ross is here. We need Robert Brawback. All right, could I see the file on Robert Lopez, please?
That case, Clayton mentioned, he was your judge. It's gonna be, that one in particular is gonna be TIC in the PSI.
Okay.
The case that she pled to.
So when is his PSI scheduled for?
November 8th, 12th? I know it's in November. But I don't
Okay,
remember the date.
all righty. Let me put it in. Is Robert Lopez out here? Mr. Lopez, if you'll come down, please. All right, Mr. Lopez, your attorney is actually out of the country. So we were scheduled for October 29th, but it's been moved to November 12th. So that's when you'll come back for your sentencing.
All right.
All right, you have any questions?
Do I have to take like another like a tap or
No, you do not.
I'm just gonna wait to come back?
Yes. So my understanding is all of the evaluations have been completed. Is that correct, probation? It's Robert C. Lopez. Do you need a cause number? It is 2023-8809. And if everything's been completed, you won't need to do another one.
She has further to call me appointment for services on 11/7.
Okay, well, this works out great. So they have one more thing for you to do, but it's not the TAP evaluation, okay? So just make sure that you keep up with all of the appointments. You understand?
Yes.
All right, thank you.
I think.
These glasses destroyed a multi-billion-dollar industry.
Hello.
Don't know.
All right. So on this case, where are we on discovery?
Judge, that's what the prosecutor and I were just talking about. I am in the process of trying to go through everything that the state, I guess, has uploaded. I don't know whether anything's missing or not. I did ask about a crash report, but the prosecutor tells me there is no crash report.
Okay.
So I still need some time to go through that. And in this case, I think, Judge, I need to file a motion for an investigator. There's some things that need to be investigated.
Okay. All right, Ms. Ferguson, give me a 30-day reset for discovery.
Oh, we can do that November. 30 days, mine's on the Thanksgiving, the 28th.
Well, I tell you what then, let's. Well, we can't do November 4th.
I mean,
'cause-
no,
That's Monday, isn't it?
Yeah.
I need a little bit more time than that, I think.
All right, I tell you what, this is what we're gonna do, sir. We're gonna put you down for December 2nd. And counsel, you need to have filed the motion for an investigator before then,
All right.
and then we'll see where we are on discovery. Do you have
Okay.
any questions?
No, ma'am.
Okay,
Okay, Judge, may we be excused?
Yes.
Every time.
Stop paying out of pocket for groceries in 2025.
All right, bye-bye. Sable Cassiano?
Yes, Your Honor.
Yes.
Your Honor. Judge, last week you were kind enough, I was out of county and you reset it to 31st. And when I notified my client, she goes, I'm getting married that day. And she had,
Well, maybe I'm saving her.
maybe, Your Honor.
Yeah.
And I had, she had mentioned that when you asked me about the date,
Mhm.
I didn't remember that. I'm just asking for any time the following week, Your Honor. Obviously, I'm at your disposal. I just hate making a mess of this thing.
No problem. The 7th?
The 7th works perfect.
All right. All right, we'll come back on the 7th.
Yes.
You have,
I have great contact with her.
all right.
I'll let her know right now.
All right, thank you.
Thank you, Judge.
All right, Norma, on this one, it's being recalled for the 7th. Yes.
So, can we bring Miss Chelsea back on?
Mr. Olson, this is his first setting. He was bonded out on habeas some time ago, but
All right, Mr. Olson, come down. Hmm?
He's got a shattered ankle, Your Honor.
Oh, I'm so sorry. Oh, you can remain in the box. I didn't know your ankle was shattered. I can't see over the computers. All right, so where are we on discovery?
I believe.
The court has received two questions from the jury. Have both the state and the defense had an opportunity to review the questions? State,
Yes, Judge.
defense?
Yes, Your Honor.
All right. First question, Judge, if a sentence of longer than 2 years is decided, if parole is authorized, how long will the defendant remain or could remain on parole? The court proposes the following supplemental charge. With reference to your inquiry, you have all the law before you. Please continue your deliberations. Any objection to that supplemental charge? State,
No, Judge.
defense.
No, Your Honor.
Any objection to sending the answers back to the jury?
No. No, Judge.
Next question, Judge, if a sentence of longer than 2 years is decided and the defendant is eligible for parole after 2 years, will he be allowed to contact the victim if he is on parole? The court proposes the following supplemental charge. With reference to your inquiry, you have all the law before you. Please continue your deliberations. Any objections to the supplemental charge with regards to that question? State,
No, Judge.
defense?
No.
Any objection to sending the answer back to the jury?
No objections. No.
All right, thank you. All right, if everyone please remain in the courtroom.
Yes, Judge.
All right, so why should I give him 5 years? Because the complainant in this case is the same complainant that he has the new case on.
He walked into the courtroom with a deal for 5 years, thinking this was all just a formality. He was wrong. This is Juan Carlos Aguirre Jr., a man accepting a plea deal for assaulting his partner. The prosecution is
5-2, could I have parties announce?
Your Honor, there's also the MTR.
Yeah, I'm gonna take this up first.
Can we do the MTR first?
Why are we doing the MTR first?
For purposes of the plea on the waiver and this, they're gonna be running concurrently the sentences.
I can still say it's running concurrently.
All
All
right.
right.
Sorry, Rick Payne for the state of Texas.
Donald Wilson for the defense.
And are you Mr. Aguirre?
Yes, ma'am.
Counsel, you received all discovery?
Yes, I have.
Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Aguirre, did you review the waiver of indictment, reading of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure?
Yes, ma'am.
Birmingham homeowners, did you know there are
He has certain rights. He has the right to have the passage of 2 days upon the presentation of the information, and he has the right of 10 days to prepare for trial. And you have a right to have a grand jury hear the evidence in this case and make a decision on whether there is sufficient evidence to hold you over for trial. Do you understand?
Yes, ma'am.
By entering into a plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea today?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the felony information with your attorney? Did you understand it?
Yes, ma'am.
Counsel, you're waiving the reading?
Yes, we are.
State, and you're proceeding as the information is presented?
Yes, we are, Your Honor.
Mr. Aguirre, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
By information, you're charged with assault family household member with a previous conviction. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, ma'am.
Did you understand by entering this plea, you're giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
You see this whole "do you understand" routine from the judge? That's not just later claiming he was to a jury trial. That's the policy. Every yes he gives.
So,
Do you believe he's currently competent and was legally sane at the time of the offense?
yes, sir.
Mr. Gary, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand if you're not a U.S. citizen, you can be deported, not allowed re-entry, and denied naturalization?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,500 fine. The state will take in consideration 2025 AL 006681 and 2025 PF 31338. And this will run concurrent with
I have the case number.
2020 CR 12202. Did you understand that to be the plea?
Yes, ma'am.
So now he thinks he's got this 5-year plea bargain locked down. A little naive, right? That deal his lawyer made with the prosecutor, it's worth less than a politician's promise. It's a suggestion, nothing more than a pinky swear. The judge is the only one in the room with real power, and she couldn't care less what the lawyers agreed to.
Defense?
Yes.
State?
There is, with the exception of, I had put restitution, should there be any, I know that he would be entitled to restitution here.
All right, it's gonna be restitution if any. Let me just tell you, if they're sending you to prison and your counsel is waiving a PSI, then whatever that restitution amount that person claims, that's gonna be the restitution amount. And when you're up for parole, they'll take it up with parole. Do you understand?
Yes, ma'am.
All right, restitution, if any, to Anessa Nicole Guerra. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated primary custodial parent?
Yes, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
By signing that I'm sorry, not appeal. Did you review the paragraph entitled Waiver of Appeal with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. At this time, state orders into evidence. It's Exhibit 1 with all attachments. No objection, Your Honor.
All right. Did you review the document entitled Trial Court Certification of Defendants? I'm sorry, did you review the document entitled Waiver and the Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call and the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor.
The rumors are true. You don't have
was kind of a tough decision for Mr. Geary to come to, but he thinks it's in his best interest and he would ask the court to go along with the plea bargain that it's taken us quite some time to negotiate, but I think he wants to get this behind him. It's unfortunate that we've ended up here, but I think he is ready to move on and become a productive citizen once he gets this behind him.
All right, the court is going to sentence you to 5 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Anissa Nicole Guerra. There's a $1,500 fine. State is taking in consideration 2025 AL 006681, 2025 PF 31338. And this will run concurrent with 2020 CR 12202. And there's to be no unsupervised contact with minors. Is there anything else with regards to sentencing?
No, you're right.
Just whenever we're finished with this and the MTR, we have the victim present who wishes to do victim impact statement.
Okay. All right, we're proceeding with 2020 CR 12202. Did you review the motion to enter adjudication of guilty and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Juan Carlos Aguirre Jr. who was placed on deferred adjudication in 2020 CR 12202
Yes.
for the offense of assault, family choking, strangulation on March 3rd, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
And here's where the whole thing goes completely off the rails. This new assault is only half the problem. The real kicker, he was already on probation for attacking the very same woman. Pleading true to violating that, that's like getting caught with your hand in the cookie jar when you're supposed to be hosting a diabetes convention. It just gave the judge all the ammunition she needed.
All right, state.
Yes, Your Honor, violation of condition number 15. On or about the 12th day of May, 2021, in Bexar County, Texas, the defendant, Juan Carlos Aguirre Jr., did then and there fail to attend, comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following counseling education program, state accredited battering intervention and prevention program, in violation of condition number 15.
How do you plead to that? True or not true?
True. State will waive the remaining violations, Your Honor.
Any objection?
Object.
Did you understand by pleading true to violation of condition number 15, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 15?
Yes, ma'am.
Court would find violation of condition 15 true. Is there a proposed agreement?
There is, Your Honor. That is to revoke the defendant's probation, adjudicate him guilty, and sentence him to 5 years TDC.
All right, so why should I give him 5 years? Because the complainant in this case is the same complainant that he has the new case on. And so why should I do this?
The lawyers say 5 years. The judge looks at them like they've grown a second head, and she asks, why should I do that? You can see the defense attorney's soul leave his body. He starts doing a little song and dance, talking about some battering intervention program. His client almost finished. Almost. That's like telling your wife you almost didn't wreck the car. It means absolutely nothing.
Judge, if we're speaking about this probation, this deferred adjudication, Mr. Geary was doing the things he was supposed to be doing at the time. He was enrolled in BIP. In fact, if you look at the records, I believe he did all but 4 classes of the BIP. But because of other circumstances, the MTR was filed on him, and he did not complete it. There was some other things going on in his home life and stuff. I believe had some family health issues and stuff, but he was doing the things he was supposed to be doing. He just didn't complete it because of the circumstances. So that makes him not a good candidate for probation. But I don't think to punish him in excess for something that's occurred after this probation expired is fundamentally fair on the original deferred.
No, I mean, because he hasn't learned anything. And I don't know what's happening in his relationships, but it doesn't appear he's learned anything. And I don't know why I should sentence him to just 5 years when he's been sentenced on assault family household member with a previous conviction, which means there's a previous conviction. And it's against the same complainant that he's on probation for. State, why should I give him 5 years?
It just seems that in the best interest, considering, yes, it's the same victim, but for efficiency and judicial purposes for both cases to run concurrently together.
All right, this is what the court is going to do. The court is finding 15 true. The court is going to grant the motion, find you guilty, revoke, sentence you to $1,000 fine, time and money run concurrent. There's an affirmative finding of family violence. This will run concurrent with 2025 CR 011524. There's to be no contact with Anissa Guerra. There's to be no residing in a household with minors. There's to be no unsupervised contact with minors, and the court is going to sentence you to 8 years in the prison.
See, the judge is no fool. She sees the pattern. You assault the same person, get a break with probation, and then you go and do the exact same thing again. That's not a mistake. That's a habit. So that 5-year deal everyone was so proud of, she tore it up and set it on fire. The lawyers wanted 5. She gave him 8. Why? Because this wasn't about a deal anymore. This was about judicial discretion, plain and simple.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it?
Yes, for the most
You do
part.
have a limited right to appeal. That right to appeal is that as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence and a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, you're gonna have to start making better decisions. Otherwise, you're gonna find yourself in and out of somebody's prison. You understand?
Yes, ma'am.
And your relationship with her is over.
Oh,
You
yes,
understand?
ma'am.
All right, good luck to you.
So, in the end, Juan Carlos Aguirre Jr. walked into court with a 5-year deal and walked out with an 8-year prison sentence. He thought he had a path forward, but the judge closed the door. Was this the right call? Or did the judge let her personal feelings override a deal made in good faith? And more importantly, does a longer sentence actually create justice for the victim? Or does it just create a more resentful man who will eventually be released? Drop your thoughts below.
That's it for today, everybody. I'm wishing, I'm hoping that you all have a wonderful Thanksgiving holiday tomorrow. I will not be here tomorrow. I will see you guys on Friday at 3:00 p.m. Until then, ciao, ciao, and ta-ta. You all have a wonderful holiday and a wonderful rest of your evening. I will see you guys on Friday.
Come down to it all with your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all. can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. To all you do, from the highest peak, I can see it through. With your care and touch, everything